Hey, welcome back, everybody. It's time once again for another episode of Health Talks with Dr. Trinh. The one show, maybe the only show, that tries to tackle today's difficult health topics in a way that we can all understand and do something about it. With the man who's always trying to do something about it, Dr. Trinh. Welcome, sir.
Welcome. Are we actually live? I don't see that we're live.
It should be. Let's double check if we're live. We're live on YouTube. It should be. I'm on the wrong channel. Okay, we're live on a different YouTube channel. Let's get you on the YouTube channel while we're discussing this here this morning.
I'm live on Facebook.
Yes, I understand. Facebook is where it's all at. I'm telling you, Facebook is the key.
We're really professional here, Mark. It's like, how do we start?
I like it.
We should be live now. Yes, we should be live there. Are we live? Do you see us now?
Let me see. I see us live now, yes.
There we go. Welcome, everybody, to Health Talks with Dr. Trinh. And let's get our guests in here today. We'll get them all on the same screen. Introduce who you brought along today here and why. Who'd you bring, Dr. Trinh, and why did you bring him on?
Why did I bring an attorney on today?
Yeah. We hate attorneys. I tried to be an attorney for a while. I've been bitter ever since.
Why did you bring an attorney on today? That's a good question. Good morning, Jennifer. Good morning, Sherry. Good morning, Dan. Sherry, Dan, Jen, why did we bring on an attorney today? Do you want to see an attorney on here? This is attorney Mark Fitter here. This
is Health Talks. This isn't legal talks. This is Health Talks.
I know. Why did we bring on an attorney? Good morning, Patricia. Good morning, Lillian. Dr. Lillian Tran's on. I brought on an attorney, Lillian. It's like I'm bringing on the dark side.
Yeah, that's right. Oh my goodness. I didn't want to say he looks like a nice guy, but all attorneys, come on, forget it.
He looks like a nice guy, but yeah, he's got no hair. Is that what happened when you study law?
Well, because every time you go into law, you go like, oh my God, I can't believe I'm doing this. And then you lose all your hair. That's what happens.
The hair comes off?
Yeah, that happened in law school.
Right. Yeah.
You lost your hair in law school?
Yeah.
Believe me.
I love it.
I went to law school for 1 year at William & Mary in Williamsburg, Virginia, this prestigious law school. I hated every second I was there. Oh my goodness. Man, I'll tell you what I hated about law school. They were always debating who could win. And I'm always saying, well, who should win? That's not your job. That's not your job. Your job's to figure out who could win. And you could flip sides. Now argue the other side. He did it. No, he didn't do it. And I'm like, well, that's crazy.
Oh, I love it. You're bringing back good memories.
You guys on Facebook, do you have any attorney questions?
Well, while they're doing that, I have one. Mark and I were talking about. Seriously, I'll tell you why it's a good thing to have him on. Because we keep talking about the continuing COVID crisis and the continuing chaos. And everybody, I was just having a discussion with my neighbor the other day, who's much more conservative than I am. And he's like, I don't get why we're still all shut down. You know, it's the flu. Okay, so some of us are going to get sick and die. But why are we all shut down? I said, because of the lawyers. Because everybody's afraid to get sued. Seriously. I hear people over and over again saying, oh my God, I had somebody that just signed a lease. And they were saying that they had to sign away the right that if they were going to come into the building, they had to sign away their right to sue the landlord because of COVID. If we're going to let you in, even if we, the landlord, are irresponsible, even if we are negligent, we let a caravan of COVID people come in. You can't sue us or won't sue us. You agree to that, or we're not letting you in the building. And Target and restaurants and everybody else, they're afraid that their employees are going to sue them. Hey, you said it was safe to come in. And their customers are going to sue them. Hey, you said it was safe to come in, and I got sick at your place. It's your fault. What do you say to that, Mark? Fitter? Sorry, Witter.
Yeah, that's a really good question, and there's a lot of theories today as to why our governor is responding as he is and what he's doing.
Right.
But let me just talk about the issue of not suing someone. So you mentioned, for instance, going in to look at a house. Now, yes. I practice in the area of estate law, which is wills, trust, probate, and trust administration. and also practice in the area of real estate. So I know about what you're talking about. And then also in business representation. So right now, if you're a realtor, for instance, and you're going to show a house, if you go to the California Association of Realtors, you'll see there's a form that agents have to use, and their broker's going to make them use, that people have to fill out and agree that they're going to adhere to certain conduct to go visit a house today.
Right.
So that's required. And as you were saying, someone else might be having you sign something. So let me just talk a little bit about waivers, because we see those frequently, and not just now during COVID, but you see them even if you go to a baseball game. You know, by buying that ticket, you are in a sense waiving some of your rights.
I'm going to interrupt you because I remember a handful of cases. I went to law school in the early 80s. So, you know, there were certain classic cases they make you study in the first year. And when it comes to liability, I was shocked. Baseball was the famous case in the 20s or something. Somebody got bonked on the head with a baseball. And the people said, hey, you assumed the liability. You assume that you're going to be in danger. You can't come back and sue us. In fact, it says so on the back of the baseball ticket. We're not responsible. And the court, and in some cases, the courts say yes. In some cases, the courts come back and say, no, I don't care. You can't sign away your liability. You can't say, I'm going to get bonked in the head, and therefore I'm going to accept this. And yet they try. Every place you park your car says, we're not responsible if you break it in. Yes, you are.
Right. So here's the thing. Attorneys can put whatever they want to into a contract.
Right.
It doesn't mean it's going to hold up.
Right.
So it is smart for the attorney to put in every which way a waiver can be put in to say, you can't sue us no matter what happens, you can't sue us. That doesn't mean they can't get sued. That's just what attorneys do, and that's what they should do. But when you waive your rights, it's really important. There's two key elements. The waiver has to be knowingly and intelligently signed. In other words, you have to first have capacity to contract. Any sort of contract, you must have capacity, your mental faculty.
You can't be drunk when you signed it here.
Well, that's
Maybe.
a whole other topic. And that depends on if it was voluntarily intoxication.
They're feeding you liquors to
involuntary.
sign this thing here, saying, here, have a few more drinks. And then you're, oh, okay, I'll sign away your life here. No, I know that.
Yeah, that's another topic, but maybe we'll get to that. So you have to be, in other words, intelligently means that you understand what you're signing.
Right.
And you understand what rights you're waiving and the danger you might be in.
Right.
So when you buy a ticket to a baseball game, in a sense, you are assuming that you may get hit with a baseball because you're in a baseball game.
Right.
And so you shouldn't be on your cell phone like most of us are at baseball games anyways, because sometimes they get a little slow. So if you're on your cell phone and you get hit in the head, you know, that would be a difficult case to win, I think, because you weren't paying attention, and you should be.
Right.
However, if, you know, you're sitting close to third base and the batter hits a ball off his bat and it flies back, you know, Mach 9 miles per hour,
right.
and you don't even have time to cover up, in that case, you may have a lawsuit that you could pursue. So it kind of depends, but just by agreeing to a waiver does not mean that you wouldn't have a lawsuit, because everyone puts those in.
Talk to the bigger issue.
I have a question here.
Okay.
Jennifer is asking, is it illegal to fire an employee due to the fear of COVID at work? Let's say the employee doesn't want to come into work due to fear of COVID.
Right. No, it's a huge issue, and they're going to have the same thing with schools. I'm not sending my kid to school. I'm not coming into work. Sorry, I'm just afraid to come in, and I don't think it's safe yet. Well, you got to come in.
Does the employer have the right to fire you if you don't come in due to that fear? I don't know.
Okay, so let me do my little lawyer speech before I answer that
question.
Yes,
right. Here we go.
Everything I'm going to say is going to sound like legal advice, and now I'm going to tell you it's not legal advice.
Right.
Because
he doesn't want to be sued. Right.
Every circumstance is unique, and so I'll give you general legal principles.
Yeah.
So another lawyer answer, it depends.
Right.
It depends on the situation. And I was just actually briefed at a recent update on COVID restrictions. And it would probably depend on that particular employee. Now, if this is an employee that's maybe the early 20s, completely healthy, no health issues, and he just says, I'm afraid to come in because of COVID, you probably have a better case to release that employee as opposed to an employee that has some sort of disability or an illness. If that's the case, then I would really hesitate in terminating that employee because you might have an issue with the ADA, American Disability Act, or some other sort of handicapped issue. So if your employee says, hey, I'm afraid to come in because I might get COVID and I could die, I wouldn't just leave it at that. I would ask questions. I would ask, tell me about your fear. Do you have any medical conditions that might make you more susceptible or might be a situation where your case might be worse if you got COVID? Ask those questions. And my thought is if there's anything close to, well, I got a kidney issue, I smoke, I'm a heavy smoker, I'm concerned about that, even though that is self-inducing. So my sense is that if there's any sort of health issue at all, I would sort of stray away from terminating them. But if there's no health issue, I would say, well, it's difficult because we're all at risk and we're living by what our government is telling us we can do and can't do. And the government is saying it is safe to come to work and wear a mask. So we're abiding by what the government is doing. So sometimes we hate our government, but sometimes we have to rely on what they say and go by their guidelines. So I think if you're following their guidelines and the person's healthy, they should probably show up.
So let me go one bit further. I'm not an attorney, as Mark. I'll do my disclaimer, but I play one on the radio, and therefore I'm going to tell you what my perception of this based on 1 year of law school. That if you're really smart employer, you're going to not say anything about why you fired him. There's just no job. Sorry, we've cut back, and will company? The fear is that companies will use this downtime to do that, to trim the force, to cull the herd, to get rid of the ones. I've been trying to get rid of Dr. Trinh for years. He's been a pain in my butt. I'm just going to forget it. I'm not going to use COVID as an issue. I'm going to use, just business is slow. This is an at-will state where you're employed at will, at the will of the employer. And as long as I don't foolishly admit that I fired you for some suable reason, you're a protected category, one of the 4 or 5 protected categories, your race, creed, religion, all these things, or I don't fire you because of something, your disability or your fear of coming. I'm just going to fire you because, times are tough.
Well, let me say something to that because you're not completely exculpated from liability if you do that. So California is an at-will state, but if you have a contract, that's a different situation.
Yes,
there's other factors that play in. But beyond that, even if it is an at-will employee, if you terminate them, it has to be in good faith, or they could still come back and sue you for wrongful termination. So you might say, hey, I got this employee, they're just, I think they should be working, but they're not. I'm just going to say I'm downsizing.
Right.
So you better truly be downsizing, because if you fire them and 2 weeks later you replace that person, then they could come back against you with a wrongful termination suit, because even though it's at will, it has to be in good faith.
Right.
So you can't just fire them and say, hey, I downsized. Oh, all of a sudden business start booming. You better show your business did boom. And so you can do that, but again, the law is very clear. It's got to be in good faith if you're truly doing that.
And that's where they rely on what you say. That's why they don't want to say anything. You're just terminated. Zip. I'm not going to say anything. The minute I start admitting why or how or whatever, then some crafty lawyer's going to say, aha, we got you. See, you admitted it. You said.
Got a question on Facebook from Dan. He says, what about a person with mild dementia signing a contract?
Mm-hmm.
Like an older person signing a contract.
Yes, right.
Who's very forgetful.
Right. So here's the thing. In order to contract, you have to have capacity. The capacity means you understand what you're doing, you understand the risk, the reward, and you're clear thinking. And so, but here's the deal. The person that may be incapacitated that contracts can hold a person on the other side to that contract, but they can't necessarily hold the person with dementia to the contract. So it's at a disadvantage for you to sign a contract with someone who may be compromised in that way. In the same way, if you sign a contract with a minor, the minor can hold you to the contract, but you cannot hold them to the contract.
Right.
There's some extenuating circumstances. If the minor, in essence, re-ups, validates that contract eventually, then they might be held to it. But if a person has some sort of dementia, let's say they signed a contract to buy a car, and then the next day their kids are like, hey, you can't afford that. You can go back to the car dealer and say, hey, dad has dementia and he should not be signing a contract. If the dealer was smart, they probably would just let him out of it. But if they don't, then you would probably have to go to his physician and get some sort of statement from the physician. There's a form they can fill out too, that says that he's compromised in his mentation and such like that. And that's very strong evidence that he should not.
I'll give you another one that I remember from law school, and this is another kind of example of, well, it depends classic answer here. What about if it's unequal, I forget what they call it, but unequal power? You're the powerful employer, and you say, you must come to work, and I'm the poor, desperate person who relies on this job, and I'm sick, and I got supporting my mother and 14 people. I can't afford to say no, so I say yes to everything. And then later on, I say, well, gee, I agreed to it, but what choice did I have? You were forcing my hand here. We were in unequal positions.
Right. What you're talking about is the theory of unconscionability.
Right.
And if a contract is unconscionable, then the court will not enforce it. But that's pretty slim. Usually, hopefully, employers are smart enough to have attorneys that draft contracts that put the material portions right up front. Mm-hmm. A material issue is something that would affect your decision. So when someone says, hey, that was material, what they mean is that issue would affect whether or not you contract or not, whether or not you agree.
Right.
There's a lot of things in contracts that may or may not affect your desire to agree to the contract, but if it's material, so it's unconscionable, and that would be taking advantage of a person. And that could be a very sophisticated contract presented to a very unsophisticated person.
Right, exactly. That's what they went through with the Consumer Protection Act, was that basically banks were getting people to sign stuff and they didn't even know what they were signing. It was in there legally, but it was so buried and so difficult for an average person to grasp that many of them didn't realize until it happened. Oh, I didn't know on page 63 that I was going to do this.
Yeah, and if that were the case, then the person that made the contract would have a difficult time enforcing it. Generally, if there's vagueness or issues with the contract, it's construed against the maker of the contract.
Right.
You can try to put a clause in that says, hey, no one's better or worse in this contract, and you can't hold us more liable, but that probably wouldn't hold up.
So let's go back to the key question on everybody's mind is what I threw out as a provocative statement. Is the threat of lawsuits in our litigious society affecting how quickly we reopen and how we reopen? In that all businesses are terrified of letting their employees in, of letting their customers back in, not for fear that they're really sick, but for fear that they're going to blame them and sue them. You said it was safe to come in. I did. I got sick.
Yeah. Well, I can tell you in my personal experience in my business rep component of my work, of my practice, I have not seen that from employees. Mm-hmm. Employers. What I've seen from employers is they want to reopen their businesses. Because this is their livelihood, and they're saying, hey, if something happens, but this is my life. This is my livelihood. I've had people that own restaurants contact me, and they're not looking for ways to stay closed. They're looking for ways to open up.
Right. Clearly. Yeah.
For instance, where we live, there's sort of a main street, old town, and virtually all the restaurants have built enclosures outside. Mm-hmm. And those enclosures are filled every night with people wanting to have dinner out. Mm-hmm. Mm-hmm. So my personal experience is people, by and large, are not so fearful of this. They're more frustrated with saying, hey, let us get out there, and life is full of risks, Mm-hmm. So,
but does that apply to like big landlords and the malls and the big chains, the big chains want to open, But I see some of the malls and everything hesitating because if they do, again, that's all waivers. You're going to sign some waiver. You're coming into the mall. You're going to sign some waiver. You're here. You're going to test yourself. Once somebody told me that, here's another strange one. If you go into a mall, some of them won't test you. And the reason is because if they test wrong, then they're liable. I tested your temperature. It looked okay on my meter. Come on in. And then later on it wasn't. So they'd much rather you state, I have no symptoms, rather than them try and judge whether you have symptoms.
Yeah. So that's a good question. And what I can tell you is that generally smart business owners, malls, whatever, are going by the edicts that the governor puts out.
Right.
And so if you go by those, then it's really hard to say the person was negligent. Because negligence involves certain elements as well. And if you are following the law, it's difficult to say that you were negligent. Now, if the law says you can open up, but you have to have social distancing, you need to be 6 feet apart, people have to wear masks. If you start allowing people to come into your establishment without a mask, yes, then there's negligence. But if you're simply abiding by what Governor Newsom says you have to do, then it would be difficult to prove negligence in that.
But don't you think smart lawyers are going to try and say, yes, okay, you complied with the basic thing. You made people wear a mask when you come in, but you didn't clean enough. You didn't really enforce the distancing enough. You didn't do this. You didn't do that. And they're going to find things that are going to, and you're going to say, I did what the governor told me. I did what Dr. Trinh told me to do. I did what the health people told me to do. So you didn't do enough.
Right.
A reasonable person would have done more. You didn't do enough.
Yeah, that's I love your questions. So here's the thing. This goes to kind of a deeper issue.
Right.
People come to me all the time and say, hey, if I do this, can I get sued?
Yeah.
And I say, sure. Anyone pretty much can sue anyone for anything.
Yeah.
Okay.
Mm-hmm.
However, let's say it's a civil suit, right? And it's one of your issues. Well, I came in and, you were abiding, but I still got sick.
Right.
So if you sue someone and it's a frivolous lawsuit and they lose, you can then come back against them for an abuse of process lawsuit.
Right.
And sue them for that. So it's not just like it's free, willy-nilly, hey, I'm just going to go sue everyone. You become a fictitious litigator. And in some cases, the court in the future would restrict you from lawsuits if you have too many of them and they're all frivolous. So you got to be careful. Just because some lawyer says, hey, I'll take your case and I'll sue them all for you.
Mm-hmm.
You better make sure you have a good case, because when an attorney takes on a case and takes on a lawsuit, the attorney is signing that complaint. And they must sign in good faith. They truly believe their client has a case and are meeting the elements needed to prosecute that case. So if they sign in bad faith and those elements aren't there and the defendant gets a demur, in California it's a demur, or there's a non-suit or something like that, and later on a summary judgment, if it basically gets kicked out, that's a really good time for the defendant to come in and say, hey, you know what? Not only do we want something filed against this attorney for a bad faith lawsuit, we're going to sue the plaintiff because they didn't even have a case. So you got to be really careful. It's not just like you go out there and start suing people. Hopefully your attorney is an integritous person and lets you know if he truly believes you have a case. Otherwise, you could be in hot water.
But don't we live in a litigious society? Take, for example, the workman's comp. Take a slip and fall. I was in the restaurant business for a while. All of these things that are, many in the business side are saying these are being abused. These are being oversued. And the hit and run, the bump and run car crashes and stuff here. Oh, I was fine, and now I've got whiplash and everything else. And they just settle because it's simpler just to pay the $10,000 than to fight these little annoyances. Let's pay the slip and fall suits at the restaurant. Just pay them off. Maybe it's our fault. Maybe it did. But there are con artists that take advantage of this stuff and go from restaurant to restaurant and do this. There are con artists. There was one reportedly when I was in the restaurant business a number of years ago, an ADA attorney who was in a wheelchair, who was supposedly, I don't know if this is anecdotal or real, was going around from restaurant to restaurant finding every little bump and suing people just because he could. And he made a ton of money doing it. Lots of abuses which fill the courts with frivolous lawsuits, or which, in the hope that the companies, the deep pockets who are being sued, will just pay them off.
That's a really good point, and that actually happens. One of my friends who owns a large business and another friend who's a litigator told me about an attorney who was an ADA attorney, and he had a guy going like parking lot to parking lot, just looking for whether they were following the code.
Discrepancies,
just
right?
Filing numerous lawsuits, and a lot of those lawsuits were very successful. But yeah, so if, like, let's say you own a restaurant and someone slips and falls, and there's slip and fall doctrine too, as far as what's going to fly and what's not going to fly.
Right.
But if that's the case, usually, hopefully, the person who owns the establishment is insured. In that case, you turn it over to your insurance company, and the claims adjuster will typically upfront decide whether or not it's a claim they want to pay out. And if they don't want to pay it out and the person decides to sue, then generally the insurance company's attorneys take over and fight that suit for you because they don't want to pay it out. So, and you got to be careful, because if you're one of those people that does just kind of go from suit to suit, the court can tag you, and they can tag you, and so that in the future, if you want to file a suit, you first have to apply to the court to file that suit. You can't just start filing, a suit every month and suing people, and those suits don't, result for anything. So once you get that tag on you, it's kind of sad, because you feel like part of your liberty as a citizen of the country has been taken away.
Right.
Because you can't just go file a lawsuit if you want to. You actually have to apply to the court to file a suit. So
do you
have a question here on Facebook. Sherry asks, let's say this was a COVID-related lawsuit, and you got COVID somewhere at a restaurant or
at your employer,
you wanted to sue the restaurant, or and the question is, how can you prove where you caught COVID?
That's the key. Yeah.
How do you know you caught it there versus somewhere else?
Yeah, that's a great question. It's not unlike a person that thinks they got some sort of food poisoning from a restaurant, right? How do you prove that you got sick from their food? What if you ate at, a popular fast food restaurant last night, and then, today you got very sick and, throwing up and those type of things? How do you prove that? So COVID would probably be more challenging, but let me you didn't ask about the food poisoning, but since it's a related topic. So it's not as simple as just saying, hey, I ate there last night and now I'm sick. If you're smart, and this is kind of gross, Dr. Trinh won't mind, but if you throw up, you're probably going to want to save some of that.
Oh, okay.
To have it tested to see what type of bacteria it is that infected you. And as quickly as you can. In a perfect world, you have leftovers from that you didn't eat.
From your vomit?
Yeah.
No, from the restaurant.
Oh, okay.
Or from the vomit. Yeah, save the evidence.
You definitely want to save. You want to save some of whatever comes out of you. I'll just put it that way.
Okay.
You medical people won't mind that at all.
Evidence. This is Exhibit A.
Right.
Yeah.
My vomit.
Right.
Okay.
Yeah. There's Exhibit B too, but we won't talk about that. You're going to want to save some of that to have it tested to see what's there. And then you're going to want to see if you can get any sample of the food that you ate from the restaurant. You're going to want to find out who ate at that restaurant as best you can. Get an attorney as quickly as you can, because evidence can disappear quickly. And so you don't just want to prove that you got sick. In a perfect world, you're going to find out if someone else got sick from that restaurant too. So a lot of restaurants have video cameras, and it's going to take some quick and some good research to find out who ate there. Now, you might be able to subpoena credit card records, because most people pay by credit card. So that's another way to find out who ate at that restaurant at the same time you did, and find out if they got sick.
Wow.
So if you had the meatballs and spaghetti and you got sick, you subpoena credit card receipts, and 20 other people had it, and 20 of them got sick or none of them got sick. That's going to affect whether or not it was probably the meatballs that made you sick. So there's ways to get that evidence that you want to get.
So will the businesses, though, fight it or go along? I had a restaurant, a popular place called Kelly McHugh's for 10 years in Mission Viejo, an Irish pub with pool tables and food and everything. And we had somebody come in once and say, we went to your Taco Tuesday thing, and I got sick, food poisoning. And we thought, well, not impossible, I suppose. We did have it out for a while. It's a buffet. You know, we try and take precautions and make sure it doesn't happen, but okay. So we said we'd pay for the immediately, you know, your emergency visit and whatever else. We're not assuming liability. We're not saying yes or no, but, you know, just in the interest of being a good guy, we'll do this. And that made it go away. And it's just in the same way that insurance companies will often pay minor claims. I bumped into somebody in a car years ago. In another car, they stopped and started, and I stopped too slow, and I bumped the bumper, and I'm fine. Gee, everything's okay. And then 24 hours later, they got whiplash. They're sick. And my insurance investigator, when he came out to look at my car, had looked at their car. He says, "No way you were going more than 5 miles an hour. Physically impossible. The damage that was done was too minor. Couldn't." And he said, "I say we fight this, but my company says, the heck with it. We got too many, and we just pay them all 10 grand, and goodbye."
So, like to your specific issue with your restaurant, someone gets sick, you got to be really careful, and you're very smart not to admit anything.
Right.
So there's California
Went to
rules
law
of
school.
evidence, and there's federal rules of evidence, and they often differ. So in California, offering to pay medical bills is not admissible in a court of law. But if you make an admission along with the willingness to pay the medical bills, the admission becomes admissible.
Wow. Okay.
So if you say, "Oh gosh, we'll pay your medical bill," you're probably okay. But even before you did that, I would ask your attorney just to be sure. But I'm giving you general principles.
Yeah. Right.
You never want to say, "Oh, you got sick. I'm so sorry. Or you got sick on our food. We'll pay your medical bills." That admission can be admitted into court.
Right.
So you got to be really careful about those things.
Yeah.
So that's kind of on the food poisoning issue. On COVID, it's a little more difficult. But let's say you're the restaurant owner and someone says, "Hey, I ate there and I got sick." So first you want to contact your attorney. Hopefully you're doing your screening of your employees that you should do every day when they come to work.
Mm-hmm.
You'll want to hang on to those records to show, I checked for fever, I asked for symptoms, they all said they didn't have it. Now, if they have it, it still doesn't mean you're going to be safe.
Mm-hmm.
But then what you probably want to do is contact, the employees that were working that night and find out if any of them are sick, have any symptoms or such like that. And if they can get, retested, that's probably a good idea. You got to be careful. You don't want to be deceitful and say, "Oh my gosh, Susie had it. Let's not get her tested." Because
right.
What's going to really hurt you is you get into a court of law and they find out you tried to cover evidence.
Yes,
I mean,
right.
that's when the judge turns against you,
Right.
and everyone looks at you like, "Oh my gosh." So your $30,000 lawsuit might become a $3 million lawsuit because you're looking at punitive damages.
Mm.
So you want to avoid that. It's really important. Be smart, be honest, do your homework, check your employees when they show up to work, because if there's any issue, then you don't want them there. Make sure, here's a personal pet peeve. Make sure the mask is covering their mouth and their nose.
Mm. Yeah, right. No, not just
Like
hanging.
this?
Yes, I can't tell you how many people I see and the mask is just over the mouth. Exactly.
Yeah, right, like this, right.
This is the wrong way.
Exactly. And I just thought, oh my gosh, I don't know. But the truth is, there are people that have difficulty wearing masks
Mm-hmm.
because there's some claustrophobia, if they have asthma, things like that. They feel like they can't, and just putting the mask on can make them feel panicky. So I totally get that and sympathize. And maybe there's some other options for them that Dr. Trinh could talk about. But if they're working at a restaurant and they can't wear the proper garment and protection, they probably shouldn't be there.
But they need to be there, and they want to be there, and you're going to send them home because they're not following the guidelines, and then they're going to sue you because you're a mean guy, and I lost my house because I lost my apartment because you didn't let me work, and And so you did. And did you have proper? The judge can say, did you have proper guidelines? Did you teach them how to wear the mask? Did you show them how to wear the mask? And you say, no, I thought everybody knows how to wear a mask. And well, see, then then, I mean, it seems like there's going to be all these issues that come up, the unforeseen rabbit holes that we're going to run down. It's not enough just to say the governor said I could open, I did. I think there's going to be a lot of people trying to drill down. Did you do it safely? Did you follow the guidelines? Did you train your employees properly? And it's that preponderance of evidence. Nobody knows. But if I got 60 things that show I did my best and you got nothing, I probably win. If you got lots of things on your side and I got nothing, no, I didn't train my employees, I didn't show them how to do anything, I might lose.
Yeah, so that's really good. And I practice in business rep, I practice contract law as well. So I do a lot of contract work. And contracts are so important. And, not to say anything negative about how our government produces doctrine. I won't say anything pro or con for any side, but I will say we look at some of the things that come out of the legislature. And to be honest, sometimes we think they're throwing it out there for the lawyers to interpret and to figure out what they mean.
Right.
Because when you do a contract, it's really important not to just say what you want, what you don't want, and if this happens, here's what's going to happen, and here's what else is going to happen. So, for instance, people oftentimes will say this contract is not, you cannot modify it except if it's in writing. Okay, and I will tell you that stands up in some contracts and not in others. But let's say it does stand up. The contract might even say, you're not allowed to assign this contract.
Right.
Okay?
Leases typically, you can't. You signed a lease, you can't just assign this and give it to somebody else, right?
So you have to go further than that. You can't just say you can't assign the contract. You have to say if you assign it, the contract is null and void.
Right.
That's really important. Otherwise, you can still assign the contract. You're just liable for legal damages, but you can still assign it. They can't. In other words, that person is not off the hook of that contract. They're still obligated, just if you assign it.
Right.
So that's why it's really important if you're a business owner and you do contracts, you get a really good contract attorney, because if they don't know what they're doing, you're going to look at it and go, oh, that looks great. That's exactly what I want. That's perfect. I was just talking to a friend yesterday who had a real estate contract. It was a lease. And the lease said that when tenant gets this licensure, that their rent is going to go up.
Right.
Unfortunately, at one point they got it. At another point, they lost the license. And then they said, well, now we pay the lower rent. Well, the attorney did not put in there a clause that protected them from that. The attorney put in what they wanted. When you get your license, then you pay a higher rent.
Right.
But it didn't state clearly that once the higher rate is initiated, it cannot revert back under any circumstances. Had he put that in, this guy would be saving money on his attorney. He'd be getting his full rent and not in the middle of a lawsuit. So it's just so important when you have a contract done. That's why they cost, a little chunk of change to get done, because it's not just like their boilerplate.
Right.
There's guidelines.
So are there going to be boilerplate? I guess I'm harping on a theme here that I'm the paranoid one in the crowd here, but it just seems like this is going to be the full employment act for attorneys. This is going to create new work for new contracts that you're going to sign with your employees, new waivers you're going to try and get them to sign, new lawsuits they're going to be confronted with, frivolous or not, approvable or not, and on and on and on. It seems like we're going to have to somehow litigate our way through what this new normal is going to look like, with businesses reopening and closing and back and forth, who you can fire, who you can't fire, who you let in, who you don't let in, how you let them in, how you train them, how you track this, how you do it. It just seems like we've created a whole new area of law and lawsuits and legal work. Or am I over-fearing this?
It's really good for Mark.
Yeah. Mark's Full Employment Act. Yeah, right. But
our contract work is probably going to be busy.
Yeah.
It's unfortunate, but as you said, we live in California is very litigious.
Particularly California. Yeah, right.
And California, in a sense, is very pro-lawsuit because there's so many regulations. And it's very difficult to create a bulletproof contract.
Right.
If you're a good attorney, you do the best you can. but a good attorney on the other side is going to find holes in it. You could probably give me any contract you could find from the most brilliant attorney in the country, and I could almost guarantee you I would find holes in it and say, yeah, but if this happened, you know why? It's because you can't make contracts 1,000 pages long.
Right. And you can't anticipate everything that might happen as much as you
There's
try.
just no way. But you try to hedge it in so that you protect your client as best you can. But, there's just vulnerabilities out there. But, that's why if you've purchased a house, so for the older folks here, if you purchased a house 50, 40 years ago, you'll notice a great difference in the contract then versus now. The reason they get longer all the time is because new lawsuits come up.
Yes,
and so
right.
they expand them. But I will tell you, California is very different. So we have clients that own property in multiple states. Done a lot of work in Arizona and Texas for clients that have property there. And recently did one for a client in Arizona, and I got their contracts, and they're standard Arizona contracts. And I was just really surprised at how short it was. And this is just my opinion. It's not just anything negative against Arizona because I love the state. But the contract was so general. It said this is a contract that could be for rent, for sale, for lease. And I told the realtor in Arizona, I said, we can't do that. You're obligating this person to all of those things. So if they list their property with you, they've agreed to not just let you sell it, but if you find someone to lease it, you can lease it to them.
Yeah, right.
So I don't know what to do because that's just how they come. And I said, well, you print it out and you highlight it with a black Sharpie.
Yeah.
And you have to cross those things out. So, but California is just unique, because.
So the name of the show is Health Talks. How does law affect health? Are we going to be safer because of these legal lawsuits and standards, or are we going to become sicker? Are we going to become safer? I don't know. All of this, when it all boils out, and somehow we get into this, are we just going to make it more difficult, not just to do business, but are we going to make it safer for people to go out there, healthy?
We got a question here. That's pretty good. So the question is, let's say you went out to eat with some friends, and you came
Lawyers
home,
love these what ifs. That's what the whole law school is about. What if? What if? What if?
Exactly. And then you came home and you got sick.
Right.
You got your fever, you got COVID, and then you realize that one of your friends knew they were sick, or they knew that they live with someone who's positive with COVID, and yet they went out and hung out with you guys anyway. So is there any legal ramification or no legal ramification? Or, I mean, because that stuff's going to happen all the time, right?
So I can give you some guidance on that. First, it's going to depend on what state you're in.
Yeah. Right. I think that's a real key question. Some states are going to be, who cares? And some states are going to be,
California, for instance, I believe, it's been a while since I read this, but I believe California obliterated a law that said if you know, or didn't obliterate, but they changed the consequences. If you know you're HIV positive and you purposely have sex with someone, I believe California changed that from a felony to a misdemeanor. So you'll want to look that up. And I mention that because it depends on what state you're in as to how flexible they're going to be. Generally speaking.
Can I stop you for 1 second? What a fast, no, nobody's ever brought that up. Because let's say, okay, you're young, you're single, you have sex with somebody, but you know you got COVID. You should have known. You kind of thought you had it, but the heck with it. I'm going to do it anyway because I'm not going to get them sick. Am I, like HIV, infecting and killing them by doing this? Am I murdering somebody because I kissed them with COVID?
Yeah. Oh, there's a movie of the week.
Yeah.
Kissed with COVID.
Kissed with COVID. Kissed with COVID.
So first of all, to be successful generally in any lawsuit, there has to be damages.
Right.
So if you know you have it and you're romantically connected to someone intentionally to infect them, if they don't get sick or they have no symptoms, you probably have no suit. depending on the gravity of their illness, you may have a lawsuit if they intentionally did that. And there's a big difference in awards in something that is intentional, which is a tort, versus something that's negligence. Generally, true negligence, you're not going to be penalized as much as an intentional act.
Yes, right.
So if you know, if Joe knows Susie has had a lung transplant and has kidney issues, and she broke up with him 5 years ago, and now he wants to go make love to her and get her sick, and she gets a serious illness or dies. Those cases haven't come up yet, but if I were that attorney, I would take the suit and say, that was intentional. That was
murder by COVID. Yeah, right.
Yeah, if not first degree, at least some sort of a manslaughter case against him. But there is an issue with a guy that was out hugging people. If you read that,
yes, right.
He had COVID, so. This is all new territory. We're going to see what happens.
Or people spitting in their face. There have been instances where there was a couple nasty people that somebody should put a mask on and they spit in their face and said, there's your COVID, whatever. They intentionally spewed their spray onto somebody to make a point. And if that person did get sick, wow.
Yeah, so just on that issue, first of all, they would have a tort case for assault and battery, depending on the state, again, whether they call it assault and battery, or battery. But battery is the harmful or offensive touching of another person without consent or privilege.
Right.
So even spitting on them, knocking a plate out of their hand, anything like that, and you could have a suit. Now, if you just get bumped into as you're getting on the subway or on the bus, probably not, because there's what's called the crowded world theory, which means there's people around, you're going to be touching. But if there's intentional or harmful or
that's the
offensive
key,
touching,
right?
That could be a great case.
Did they intend to touch you? Did they intend to harm you? Did they intend to make you sick?
Correct.
Yeah, exactly.
Yeah.
Wow. Well, this is all fascinating stuff here. So 30,000 feet, we going to be better for this or worse? Are the lawyers going to make this more difficult to live in this society? Are we going to get more litigious, or are they going to make us toe the line and people are going to do the right thing and safe? And what do you think? Good or bad?
And I'm not just saying this because I'm a lawyer, but I think they're going to make it better. We live in a free society, and it's kind of like a pendulum, and the pendulum swings to extremes. And so eventually it's going to settle in the middle because of lawsuits. It's going to find a middle ground. And judges and courts are not just going to accept any suit, but they're going to find a middle ground. And it is going to help, I think, because unfortunately, because of lawsuits, people sue. Generally physicians don't like attorneys, because the only time they see them is when they're getting sued for malpractice.
Right. You're nice. I like you a little bit.
and the malpractice cost of practice has gone up so enormously because the suits have gone up enormously. So the cost of being an attorney, the danger of being, of a doctor. Yeah.
There's limits on malpractice awards, and they did that because they were just killing the medical industry. What happens is the more suits you have, the higher their insurance rates go up. The higher the insurance rates go up, the higher your co-pays go up, the higher your premiums go up. So there's a balance there, and hopefully the court will weed out those attorneys that are unscrupulous.
So you take the free market approach, that the courts in effect will find the good and the bad lawsuits will all sort of even themselves out, and over time they'll find a middle ground, and the courts in effect do create a new normal. What is an acceptable standard, a reasonable standard? That was the key word in law school, always threw me. 99% of these laws, they judge them according to a reasonable standard. What would a reasonable man do? And then we endlessly argue, I don't know, would a reasonable man do that? Would a reasonable business do that? And
exactly. And that's true. It's all about what's reasonable. And juries tend to be reasonable and logical, but they can be swayed by their emotions.
Right.
But you're going to find court cases, and hopefully one will make its way to the Supreme Court, because once they speak, that's it.
Right.
So it's not as though you're going to have, 100,000 cases that are all going to maybe mature, because once you start getting decisions, courts of equal or lower level must abide by those decisions. So if the Ninth Circuit comes down on a decision, then the Second Circuit has to abide by that, unless they're going to try to bump it up to the Supreme Court and get it, overruled.
Right.
But when a court makes a decision, other courts take notice. They
Right.
can't ignore those suits.
Stare decisis, the precedents of law.
Oh, there you go.
Wow.
That's
Yeah.
pretty good. You remember that.
I remember all these Latin phrases here. It made a big impression on me. It really did that year. I decided this is what I want to do, but it was fascinating insight, it really was, into how the law works and to why it works and all these things.
Yeah.
So now I realize that you both went to law school.
Mm,
Paul, you went to law school as well.
1 year.
Wow. And so if I was like Jesus and I died today,
Uh-huh.
I would be between you guys, a thief and a liar. Is that right?
I'll let you decide who's who, right? Wow.
I
Okay.
love it. I love it. Die like Jesus between a thief and a liar.
Yeah, exactly. Well, thank you for not being a thief or a liar and for sharing openly. So many lawyers just, it's the what if, and they always want to say, well, you know, it depends. I get you have to do that because it really does depend. Each of these are unique, and over time the courts will sift this stuff out, what's frivolous and what's real. And I think there will be, my personal opinion, I think there will be a new higher standard that businesses are going to be held to, and that will make us all safer.
Yeah.
Mark, if somebody wanted to reach you or contact you or had questions or wanted you to review their contract or real estate, how do they reach you?
So you can call us at our office. I work for a law office called Hiskey Law Firm, Hiskey. So our website is hiskeylaw.com. Our phone number is 714-961-9118. And, you know, you can find me on Facebook as well. I'm all over the place. So, you know, you can find me there. But again, the phone number is 714-961. I'm sorry, I gave it to you wrong. 714-961-1198. There we go. 714-961-1198. HiskeyLawFirm.com. You can email me. It's mfitter@hiskeylaw.com.
And will you take, does the meter start running the minute I call you, or will you spend a few minutes with me here and answer a
Hiskey
few questions?
or Hickey?
Yeah, Hiskey.
Hickey Law.
Yeah.
Hiskey, not a
No,
hickey.
you know what? I do that for a lot of people. I did that yesterday for a couple of people. No, the meter's not going to start running as soon as you call me. I'll let you know when you're going to start getting charged. But
Okay.
if you have some general questions on that, please feel free to call me. I'd be glad
Well, we're going to have to
help
cut you off because we've got another show, and I know sooner or later that you're going to charge us for all this free advice. So the meter's, so we want to end while we're still free here. Thank you so
Thanks
much.
so much, Mark.
Yeah.
Yeah, thank you guys.
Take care.
All right.
Well, there you have it. You've been listening to Health Talks with Dr. Trinh right here in Orange County's only community radio station, octalkradio.net.
When you use the Premier Rewards Gold Card from American Express, the rewards points can keep on multiplying. Buy 3 with triple points on airfare. Buy 2 with double points on gas and groceries.